want to tell you about the Environmental Voter Project. So the Environmental Voter Project, for those of you who don't know, is a nonpartisan nonprofit that is laser focused on just two things. One, we identify environmentalists who don't vote. And then two, we turn them into better voters. That's it. That's it. We're like this full-time identification and mobilization nonprofit that uses every election, local, state, and federal, as an opportunity to turn non-voting environmentalists into better voters. And so what that also means is we don't usually have programming like this. This is the first event like this that we have ever had. But we're keenly aware that this latest wave of voter suppression efforts is not only dangerous for democracy, it's particularly dangerous for the political strength of the environmental movement, which is overrepresented by young people, poor people, and people of color. So tonight's discussion is of supreme importance to all of us who care about a more powerful climate and environmental movement. So I'm really, really glad so many of you are here. And I'm just going to go ahead and introduce our guest speaker, because she's the one who knows all this stuff. Eliza Sweren-Becker serves as counsel in the Voting Rights and Elections program at the Brennan Center for Justice. She litigates voting rights cases, counsels lawmakers and administrators on voter legislation and policy, researches voting law trends, and comments on voting issues in a variety of media outlets. Prior to joining the Brennan Center, Eliza was a litigation associate in private practice. She previously served as a Ford Foundation Fellow in the ACLU's Speech Privacy and Technology Project, and she was a law clerk in Federal District Court in California. Eliza received a JD from Harvard Law School, a master's in public policy from the Harvard Kennedy School, and a bachelor's degree from Brown University. She is awesome. I know you're all going to love her, and we are enormously grateful to Eliza for sharing her time and her expertise with all of us. So please, Eliza, take it away.
Thank you, Nathaniel. I hope I live up to that very, very kind and generous introduction. And thank you all for joining on a Monday evening. I really appreciate your time and attention to democracy issues. I'm thrilled to be here, but unfortunately I'm here to talk about the latest wave of voter suppression bills that we are seeing in the wake of the 2020 election. But before I begin, I want to give you all a brief background about the Brennan Center, and I'm going to share my screen and hopefully start this PowerPoint presentation. And Nathaniel, please do let me know if for some reason my tech is not working, either sound or visually. But we at the Brennan Center are a nonpartisan law and policy institute that seeks to improve our systems of democracy and justice. We are a hybrid organization, part think tank, part advocacy group, part public interest law firm, and part communications hub. And our work in each of these areas strengthens and supports our work in the others. On the voting and elections team, the team that I'm on, we advocate for proposals to expand access to things like registration, like automatic voter registration. We advocate for voting rights restoration for people with past convictions. We advocate for early voting. And we also fight back against policies that make it harder for Americans to vote. And that includes advocacy in state houses and in Congress, and also litigation challenging these policies in court, whether it's state court or federal court. Before I turn to the backlash, I wanted to just take a moment to reflect on last year's elections, because I think that sets the stage for where we are today. Thanks to the tireless work of public officials, advocates across the country, everyday voters, 35 states and Washington, D.C. changed their policies last year to make voting more accessible, particularly during the pandemic. These changes were primarily to vote by mail, including expanding who could vote by mail, affirmatively providing mail ballot applications and mail ballots, and providing postage for returning ballots, or eliminating hard to satisfy notary or witness requirements, particularly hard to satisfy when you're trying to social distance. We also saw changes to in-person voting, including more early voting hours, additional days of early voting, and advocates filed as many as 165 lawsuits in courts across the country to protect voting rights and access. And we did see pro-voter outcomes in more than 100 cases. But we also saw that the federal courts of appeals tended to block many of these pro-voter changes. At the same time, we saw that 77 lawsuits were filed to make it harder for people to vote. And those are by the Trump campaign and the RNC in particular. And they were seeking to block everything from ballot drop boxes to limiting the days when ballots could be received. So shortening the ballot receipt deadline, essentially. Ultimately, the Supreme Court displayed a relative unwillingness to strongly protect voting rights in advance of the election, although the courts overall sort of held firm in the efforts to completely overturn state election results, which I suppose is good news, although of course we were facing really unprecedented challenges to our systems of democracy and elections. But overall, last year saw a lot of good news for elections. The first is that there was an election. At the beginning of the pandemic in March, we were all scrambling to figure out how election officials were going to be able to hold elections safely and successfully. Election officials stepped up, politicians from both sides of the aisle stepped up in expanding voting access. Businesses provided funding, PPE, they transformed stadiums and arenas into voting sites. And really all of this came because voting rights advocates and organizers tirelessly worked to register voters, protect voters, make sure that voters knew about the changing rules, and turn those voters out. So the success showed in the turnout. The presidential election turnout was 7 points higher than in 2016. And in particular, we saw mail ballot usage skyrocket, with more mail ballots cast in 2020, twice as many mail ballots cast in 2020 than in 2016. And so that really sets the stage for what we are seeing now, which is over 280 bills to restrict voting access. And that's as of the end of last week. More bills have been filed even today. We're seeing that in at least 45 states across the country. These bills are largely premised on lies about voter fraud and election irregularities, which are being used as a justification to limit voting access. And one of the sort of perverse things that is fueling that the effort to restrict voting access is we're seeing lawmakers now, rather than point specifically to allegations of voter fraud, they're saying there's so much concern now about election security and election integrity, we have to address at least people's concern, and therefore we have to pass bills that essentially make it harder to vote. But of course, that concern is fueled by the very same lawmakers advancing lies about election fraud and election integrity. So there's this circular logic that has no basis in truth, but it's still being used to limit voting access across the country, or at least to try to limit voting access across the country.
Eliza, sorry to interrupt. We're having trouble seeing the very bottom of your slide. Is it possible to maybe expand it? There we go. I think that's better.
Okay, I'm sorry about that. Here.
No, it's great. Okay, thanks. Sorry about that.
How's that? Okay, let me know if anything else comes up. There are, a couple of several trends that we're seeing. Of course, the biggest trend is efforts to restrict access to the ballot. And so that, I think, is a plain and simple backlash against the unprecedented or the historic voter turnout that we saw last year. But of particular note are efforts to limit mail voting access. Nearly half of the bills to restrict voting generally are efforts to make it harder to vote by mail. And the state lawmakers are trying to put obstacles in the way of voters at every step of the way on the path to mail voting. So for example, they are trying to make it harder to get a mail ballot. They're trying to make it harder to fill out a mail ballot by introducing photocopy ID requirements with mail ballots, for example, in Georgia, or notary requirements. And then they're trying to make it harder to deliver a mail ballot on time and to have it counted. For example, there's a proposal in Arizona that would make mail ballots due the Thursday before Election Day, which is, there's no state in the country that requires mail ballots to be due anytime earlier than the day before Election Day. It is worth noting that last year, male voters tended to be younger and less white than the male voting population historically. And that, of course, touches on something Nathaniel said earlier. I think it's no coincidence that we're seeing efforts to restrict mail ballot access just as the group of people who uses that method of voting changes, and it changes in a way that partisan politicians tend to think doesn't benefit them, particularly if they're Republicans. It's not actually clear that that's the case, because historically, mail voting was a method of voting that Republicans and Democrats use in relatively equal numbers. We're also seeing significant efforts related to voter ID requirements. There are over 60 provisions to impose new or stricter voter ID requirements. And voter ID, again, is not necessary to combat any issues of voter fraud, which as a phenomenon is extraordinarily scarce and did not affect the outcomes of any of the many races that were held last year. But voter ID is also a discriminatory policy. Voter ID costs money, even if the ID itself is free, because voters have to pay to obtain birth certificates or other documentation, incur travel expenses and wait times that take them away from their work. And those place a particular burden on people of color and people with disabilities and poor people. We also see that the forms of ID can be restricted in a discriminatory manner. For example, in Texas, gun licenses are permitted as voter ID, but university IDs are not. And of course, the population of university students across Texas is generally more diverse than the population of those with gun licenses. We're seeing lawmakers take aim at just voter registrations by making it harder for voters to register, whether that's by requiring voters present a proof of citizenship in order to get registered, or eliminating or cutting back on election day registration. And finally, we've seen more than a dozen states introduce dozens of bills to enable problematic or more aggressive purges of the voter rolls, that is the cancellation of somebody's registration. And research from my colleagues at the Brennan Center has shown that states are typically purging voters at higher rates over the last several years. And the states that were previously subject to pre-clearance under the Voting Rights Act, a regime where jurisdictions that had a history of discrimination had to get their new voting policies reviewed in DC in order to have them implemented. The jurisdictions that were previously covered by that pre-clearance regime are purging at even higher rates than uncovered jurisdictions. So basically that means jurisdictions that have a history of racial discrimination in voting are purging their voter rolls even more than other places. I want to touch on a handful of restrictive bills that we are watching and that are moving, or at least have moved somewhat since they've been introduced. This is by no means exhaustive. We are tracking well over 2,500 voting bills overall. We're tracking hundreds and hundreds of restrictive bills, but just to call attention to a handful of them, Arizona and Georgia lead the country in the the greatest number of restrictive bills. So in Arizona, Senate Bill 1485, for example, would remove voters from the permanent early voting list. So for folks who voted absentee for the first time in Arizona and are on the permanent early voting list and opted into that last year, that would end that sort of ease of operations in voting by mail. Another Arizona bill, SB 1713, would require that voters supply an ID number or voter registration number and a secondary identification document to cast an early ballot, which is what Arizona calls a mail ballot. SB 1593 there would shorten the windows for casting absentee ballots. HB 2701 would require proof of citizenship to vote. And I just want to mention HB 2826, which hasn't progressed as far as those other bills, but it is one of several bills in Arizona that would essentially give the legislature the power to review and overturn the election results for any reason or no reason at all. And I think that's a very direct reflection of the big lie that has been told about the election results last year and the lies about voter fraud and election irregularity that are, still permeating our legislative landscape. In Florida, there are a number of there are a couple of bills that are restrictive, but we are actually hearing that these bills may be vehicles to be even more restrictive as they advance through the legislature. For example, SB 90 originally just shortened the time for being on Florida's absentee list. They don't have a permanent absentee list, but they allow people to stay on for a certain duration. The bill shortens that time, but also last week, a new provision was tacked on to ban ballot drop boxes, which was a method of mail ballot delivery that many voters took advantage of and liked last year because it spared them from relying on USPS, where we saw lots of delays. Another bill out of Florida, SB 656, would allow poll workers to ask for additional information to confirm the address on somebody's ID or to ask them to recite their address. That kind of discretion and arbitrariness given to poll workers is a real recipe for intimidation and allows poll workers to choose to use that authority in a discriminatory manner. So that's of particular concern. As I mentioned, Georgia is the epicenter of this wave of voter suppression this year. There are many, many bills coming out of Georgia, but a handful to watch are two omnibus provisions, SB 241 and HB 531. They are filled with restrictions on voting, but just to name a few, SB 241 would repeal no excuse absentee voting in Georgia. That is a policy that the state has used successfully and for over a decade and was implemented by Republican leadership. The bill would allow people over 65 to vote by mail without an excuse. And that's of particular note because the people over 65 who vote in Georgia tend to skew whiter than the rest of the population. So this is a very clear effort to restrict mail voting access for voters of color and in particular Black voters. SB 241 would require a witness for mail ballots and a photocopy of ID for mail voting. That's a trend that we're seeing across the country this year, requiring potential photocopies of ID for mail ballots. And of course, it's already hard enough, as I described, to get an ID that qualifies you to vote, but then to assume that somebody's going to have access to a scanner and a printer to be able to submit their mail ballot is really outlandish, and I think puts a special burden on rural voters, on poorer voters, on younger voters. And HB 531, another omnibus bill out of Georgia, would require that photocopy of ID as well. It eliminates Sunday early voting and wouldn't allow local election officials to expand to Sundays. That again is particularly targeting Black voters who often participate through their churches in voting efforts called Souls to the Polls. 531 would also completely disenfranchise somebody who voted by accident out of precinct. So if I showed up in the right county but the wrong precinct, I wouldn't even be able to vote for the races for which I was eligible in that county if I'm in the wrong precinct. And 531 would also drastically cut the absentee ballot application window. Moving to New Hampshire, so I don't take up too much time here, several of the bills are targeting student voters in particular. So HB 429 would say that college and university IDs don't count as valid photo ID. And HB 362 would remove the ability of students to use their university address as their place of residence for voting. So that's a very clear effort to limit young voters in the franchise there in New Hampshire. Another bill in New Hampshire would require stricter ID, HB 523, and another bill, SB 31, would require purging of the voter rolls based on third-party information about somebody who may have moved out of state. And based on our reading of the bill, that looks very much like a violation of the National Voter Registration Act and reflects an issue that we're litigating right now in Indiana. We're seeing bills continue to come out of Pennsylvania. They have a much longer legislative session, so there's a bit of less of a rush there. But there's a strict purge bill, HB 143 out of Pennsylvania. A number of efforts, including HB 25 to repeal no excuse mail voting in Pennsylvania. And no excuse mail voting was enacted with lots of bipartisan support just at the end of 2019. So all of a sudden, something has made lawmakers in Pennsylvania want to take away no excuse mail voting. And it's quite clear that that is because so many voters actually took advantage of it. And for some lawmakers, they took advantage of it in a way with a political outcome that they did not particularly like. Another bill would shorten the deadline for voter registration applications. And there are still a number of bills being introduced in Pennsylvania, again, because they have that longer legislative session. Finally, in Texas, just at the end of last week, 2 omnibus bills were dropped, SB 7 and HB 6. Both of them include very substantial criminal penalties for minor violations of election law, and including criminal penalties for election officials. That is particularly galling because what we saw last year was local election officials really step up and work unbelievable hours under enormous pressure, facing death threats, really working their butts off to make sure that people could vote safely during a pandemic. And one of the trends we are seeing is state lawmakers going after those election officials who stood up for the rule of law and protected election integrity last year. SB 7 also requires registrars to send notices confirming citizenship status upon receipt of any information that a voter is not a citizen. So that could easily be abused by somebody who, very speculatively sends a list to a local registrar about people whom they suspect may not be a citizen. And then that voter will get potentially, a scary letter from their election registrar. There are a number of bills, including SB 7, that prohibit voting clerks to send out an early voting ballot or a ballot application without an affirmative request from the voter. That is in direct response to what we saw in Houston, where the registrar there affirmatively wanted to send mail ballots and mail ballot applications rather to voters in the county, and that was challenged in court, and ultimately the local registrar was not allowed to do that. HB 6 in Texas contains a number of purge provisions and many other additional criminal penalties. HB 895 would allow election officials to copy the documentation, the ID presented by voters, and it would allow election officials to photograph the entire face of a voter who does not present a photo ID or whose documents are questioned for authenticity. So that's another bill like the Florida one that gives lots of discretion, lots of opportunity for intimidation and discrimination to local election officers. And, if somebody asked to photograph me while I was about to vote, I might be scared away. So you can imagine what, other folks, and, I do this for a living, you can imagine what other folks may be thinking when they're asked to do the same. I'll leave it at there. There are a number of other bills listed and many, many others that we're tracking, but I don't want to bore you guys too much with the specifics. I will say that it's not all bad news. There are also hundreds and hundreds, well over 700 bills to make it easier to vote. We see that lawmakers looked at what happened last year and they noticed what voters like. Voters like choices, they like convenience. And we know that the policies that lower the costs and the burden on voters, like the distance to the polls or making it possible for them to vote at home, those kinds of policies increase turnout. Again, we're seeing mail voting, the clear focus. Most of the biggest chunk of bills to expand voting access are to make it easier or simpler to vote by mail. So some of these proposals include eliminating excuse requirements for absentee voting where they still exist, adding a notice and cure procedure for technical defects in mail ballots. So if you've done something wrong and you're in mail voting, you get to add your signature if you've forgotten to do it, or add your address if you've forgotten to, write it on the proper line. We're also seeing expansions to early voting days and early voting hours. We're seeing efforts to make it easier to register to vote, like, for example, the introduction in many states of automatic voter registration. And we're seeing particular momentum around restoring the right to vote for people with past convictions. We saw success in expanding the right to vote for those with past convictions last year in California by Ballot initiative, and also in Iowa through executive order. We've already seen bills to restore the right to vote to people on parole in New York and Washington State pass at least one chamber of their respective legislatures this year. And we think there's the possibility for reform this year or in the near future in Connecticut, New Mexico, Minnesota, and Virginia. And I've included our celebratory tweets from Washington and New York. Finally, I just want to close, and I know we'll be talking about this more, with what you all can do. The first and most obvious is to say vote, including in your state and local elections, and especially in your state elections. Your state lawmakers are the ones writing election laws, and those elections really matter. You can also call or write your state lawmakers in your state. So for example, if you don't live in Georgia, it's not all that helpful for you to write a state lawmaker there. But you can communicate with your state representatives, and state lawmakers tend to be more responsive than your federal representatives. So it is worth writing, it is worth calling. I would also say call and write your federal representatives, and particularly your senators. The For the People Act, HR 1 or S1, is a massive democracy reform bill that the House passed just a couple of weeks ago. And we need the Senate to pass this bill to protect voting rights across the country. It would enact nuts and bolts, common sense election reforms, and it would really, be a bulwark against all of the voter suppression bills that we are seeing across the country in state legislatures. In addition, the John Lewis Voting Rights Advancement Act would restore and strengthen the Voting Rights Act. It would reinstate the pre-clearance regime that I mentioned that's no longer in force because of a Supreme Court decision in 2013. And of course, you should support the state-based democracy reform organizations and organizers that are doing the work on the ground. So the Brennan Center is a national organization. We're not a grassroots organization, but there are phenomenal organizations across the country doing this work, registering voters, fighting back against voter suppression, and they are absolutely worth your whatever resources you can give them, including your time, because I'm sure they could help. They could use volunteers, they could use folks helping to organize. So I will leave it there, and I know we'll take some questions, but thank you all so much for listening to a long and detailed presentation about voting bills.
That was awesome. Thank you, Eliza. Thank you so much. And I've written down some questions. I know we've got some questions already that people have put into the Q&A. Please, if you have questions, start putting them in the Q&A so that we can throw them over to Eliza. While people are doing that, I'm just going to share a slide myself that will have some of the information that I think Eliza alluded to. Eliza, are you seeing that? Great. So, as Eliza mentioned, there are great voting rights organizations doing all different types of work at the national level, but also at the grassroots level that deserve your support. These organizations have nothing to do with the Environmental Voter Project, but voting is important. And so we want you guys to support these groups. The Brennan Center for Justice, where Eliza works, the Lawyers Committee for Civil Rights, Mi Familia Vota, also the state chapters of the ACLU and the League of Women Voters. These are often the plaintiffs in these cases, and they are, at least in part, bringing the lawsuits, and oftentimes in whole. The other thing that Eliza mentioned is helping voters vote. Many of you are familiar with our work at the Environmental Voter Project, but for the few of you maybe who are on this call who aren't, we have already been active in mobilizing seldom voters and non-voters to vote in over 150 elections this year in 2021. Every election is an important opportunity for us when it comes to turning non-voters into voters. So not only is our work important for voter turnout, but we work in almost all of the states that Eliza mentioned, and we are informing people how to vote. Voting is a potentially habitual behavior, and you get into a groove and it becomes part of who you are. And when the rules change all the time, it becomes confusing even for those of us who have spent our entire adult lives voting. So I know it will be in the chat, but please feel free to sign up for a training online so you can text and call voters in these states for their upcoming local and state elections. You can go to environmentalvoter.org/events. You'll get right on the phone, texting or calling people in a completely nonpartisan way, helping them know how to vote. All right, so I'm going to start with tossing some questions to you. Please, 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 folks, keep on putting stuff in the Q&A though. So the first thing, Eliza, is what are some of the major litigation hooks that a shop like yours usually uses to attack voter suppression bills like this? All right, state constitutional hooks that are often there, federal constitutional hooks, statutory hooks. What are the tools of the trade? How are you guys going after these things?
So it ranges and it depends what the particular policy is, of course. But as you know, there are federal constitutional protections for voting. So something that imposes an undue burden on the right to vote is a violation of the 14th Amendment. Racial discrimination in voting is also barred by federal law, both the Constitution and the Voting Rights Act. The Voting Rights Act had a couple of protections against racial discrimination in voting, primarily Section 2, which allows lawsuits, by private actors like us to challenge policies that discriminate. And the key with Section 2 of the Voting Rights Act is that you don't need to show intentional discrimination. You can show a discriminatory impact and causation, but you don't need to show that very thing that's hard to show when sort of the racism is insidious and not necessarily expressed. Very rarely these days do we see voting bills passed with the express intent to exclude voters of color from the polls, even if that is in fact the underlying intent. There are other federal bills like the National Voter Registration Act that particularly deals with voter registration and voter roll purges. So the Indiana litigation that I mentioned related to voter roll purges, that's a lawsuit that we've undertaken under the National Voter Registration Act, which also has a private right of action for individuals or groups to challenge state law that violates that federal law that sets the ground rules for how states are supposed to do purges. And you also mentioned state law. State laws set ground rules for how elections are supposed to go. And state constitutions actually tend to be more protective of voting rights than the federal constitution, often containing an explicit articulation of the right to vote, which is found across the US Constitution, but not necessarily in a single place. So I think given the makeup of the federal court, we are, at all levels, including the Supreme Court, we're going to start to see more and more voting rights litigation in state court. But I think it's too soon to tell what's going to happen with these voter suppressive bills, but already one of the first bills to make it to a governor's desk and get signed was a bill out of Iowa that severely shortened the early voting period. And that was immediately challenged in Iowa. So there's litigation that's happening there. So I expect, given the uptick in voter suppressive bills we are going to start seeing a corresponding uptick in litigation if and when these bills get passed.
Great, thank you. There are a whole bunch of questions on clarification on HR 1 and the John Lewis Voting Rights Amendment Act. So I wonder if we could take HR 1 first. I think people understand that there are a whole bunch of state-based efforts to change how voting happens in the states. What would big sweeping federal legislation like HR 1 be able to change? What would it not be able to change?
So one of the things that I think is very confusing about election administration in this country is that it's happening at a lot of different levels of government. You have county election officials actually doing the groundwork of election administration. You have states writing laws that apply to federal elections, and they're allowed to do that because there's a provision in the US Constitution that says states shall make laws shall make regulations for the times, places, and manner of federal elections. So that's why you often hear people saying things like, well, elections are the purview of the states and the federal government has no business messing with elections. What those people are forgetting is that the very same provision of the Constitution then goes on to say, and Congress shall make or alter those regulations. So it gives Congress not only the power to write regulations for federal elections, but to alter the regulations that the states themselves have made. So it gives this overriding power to Congress. And that's because the framers did not trust state lawmakers. They thought they were corrupt. They thought they were going to be more susceptible to partisanship or faction. And as a result, Congress has a ton of power to regulate federal elections. And that's why we have landmark election bills like the Voting Rights Act and the National Voter Registration Act. So the kinds of things that are in HR 1 are automatic voter registration, election day registration, early voting, no excuse mail voting, protections against erroneous purges, additional protections against voter intimidation and deceptive practices. There are also a whole host of provisions on ethics. There are provisions around money in politics. There are provisions around redistricting reform to prevent partisan gerrymandering. So it is a massive democracy reform bill. It is the civil rights bill of our time. And Congress has the authority to do that because they can regulate federal elections. And the Supreme Court has agreed. They've said that Congress can write a whole code of federal elections from whole cloth. And the Supreme Court has, rubber stamped legislation that deals with campaign finance, that deals with voter registration, that deals with really every aspect of elections. So this is a bill that is on strong constitutional ground, and it would be hugely effective in pushing back on the restrictions that we're seeing in the states, because we're seeing efforts to roll back early voting, repeal no excuse mail voting. We've even seeing efforts, although the bill failed in Georgia, to eliminate automatic voter registration there. So the very policies that states are trying to shrink, HR 1 would make the floor, the norm for every state in the country for federal elections. And these are really like nuts and bolts reforms that are common sense ways to make sure every American can access the ballot freely and fairly. They aren't, some of them seem like technical issues, but they would make a huge difference in making sure everybody can, cast their ballot.
Right. Thank you. And for the John Lewis Voting Rights Act, I guess, first, could you describe sort of some of the history why certain states had to go through Justice Department review when they were changing certain things around voting, how that changed, and then what the John Lewis Voting Rights Amendment Act would do to kind of switch some of the stuff back? Sure.
So one of the key provisions of the Voting Rights Act was this idea of preclearance. And what preclearance was one, a formula that decided which states or jurisdictions would be subject to it. And then the operable provision said, if you are a covered jurisdiction, you have to, when you make a change to your voting and elections policies, you have to run that through us in DC. You have to run that through the Justice Department or a federal court in DC and get it approved to make sure that it's not going to have a discriminatory effect. And that was a highly effective mechanism in making sure that voting policies did not get enacted in states that would make it harder for racial minorities to vote. And in 2013, in the Supreme Court decision, Shelby County versus Holder, the court said that formula for deciding which jurisdictions have a history of racial discrimination in voting is too old. And we can't rely on that anymore because the facts that were gathered as the basis for that formula are not sufficient. And where there was racial discrimination before, there may not be racial discrimination now. The late Justice Ginsburg wrote a very stinging dissent where she said, and I'm paraphrasing, it was much more eloquent than this, but she said something like, getting rid of preclearance now is like throwing away your umbrella when it's raining because you're not getting wet. effectively, the fact that we are not seeing racial discrimination in voting in states where there is preclearance is not evidence that there isn't racial discrimination in voting. It's evidence that this provision is working. Unfortunately, the majority of the Supreme Court didn't agree. They struck down the preclearance formula. So one of the things that the John Lewis Voting Rights Advancement Act would do is reinstate a new preclearance formula based on a record that many, many advocates across the country are building, showing which jurisdictions continue to discriminate against racial minorities in voting. There are other provisions of the bill too that strengthen protections against racial discrimination. For example, it would make it easier to get a preliminary injunction upon a showing of evidence that there's racial discrimination, and other measures that would make it easier for people to vote free from discrimination. But the preclearance provision is key, and once preclearance went away in 2013, that was another period of time where we saw a flood of voting restrictive bills, including in states passing policies that were expressly prohibited by preclearance. Once the preclearance regime went away, states like Texas, for example, or North Carolina introduced policies that were previously blocked. So it was an extremely effective method at protecting voters, and it's essential that we have it back.
So this might be a supremely unfair question to ask, so feel free to completely avoid it if you'd like, Eliza. But a lot of people are understandably bringing up the filibuster. How many of these things that are sailing through the House do you think have a chance to get through the Senate? And is one of them maybe more likely than the other?
I'm not sure whether one is more likely than the other. I think some kind of filibuster reform is going to be necessary to get one or both of these bills passed. But I think it's much more important that we talk about the policies that we want Congress to enact, and less important to talk about the the parliamentary procedures that are in place. So when you call your senators, when you're talking to your friends and family, when you're talking to other voters, what we want is for every American to have a fair shot to cast their ballot. Frankly, I don't really care on its own merit about the filibuster. I just want every state to have automatic voter registration, because we're leaving tens of millions of voters out of the process. And so I think it's incredibly important that lawmakers, and particularly senators, hear that message, that we want all Americans to have free, fair, and equal access to the ballot. And they need to figure out what to do to make that happen. And I think that, of course, is going to include some kind of filibuster reform. But the message here is about sort of democracy, and it's about voting, and they can deal with whatever parliamentary kinds of rules they want to deal with.
Right. Eileen asks an interesting question, and I know it's something that, at least in the past, the Brennan Center has done some research on, and that is the number or density of polling places in particular areas. And she's curious, and I'm sure a lot of people are curious, are there any laws, federal, state, or just, ones that you're aware of, that protect the number of voting places that need to be provided to certain communities or certain groups or in certain areas? What are the handles that you grab onto when 500 polling places are gotten rid of in Arizona or something like that?
So that is a topic that is typically governed by state law, and many states do set sort of guidelines for the number of polling places per the number of registered voters in a district or a precinct or a county or whatever it may be. We did, I think it was the Lawyers Committee that reported out on polling place closures, particularly in previously covered jurisdictions, again, going back to the Voting Rights Act. And we saw, we saw polling place closures, particularly in places that were covered by the Voting Rights Act. So again, places with a history of racial discrimination in voting were closing more polling places than other jurisdictions. In addition to this being sort of an issue of state law, one of the things that we saw last year was, at least in the primaries, a lot of polling places were closed because governors and secretaries of state didn't really know what to do in the early months of the pandemic holding an election. And many states transitioned very quickly from voting in person to expanding voting by mail and shutting down a lot of polling places. And that's because those governors and secretaries of state had the discretion under their state law to be able to do that. Sometimes that discretion is really good because it allows for it allows for us to be able to be flexible in the face of disaster. I mean, the pandemic was not something that we predicted. But I think those state governors and secretaries of state and other state election administrators learned from the experience of the primaries and didn't close polling places, at least not nearly in the same number that we saw in the primaries for the general election. One of the studies that we did in Wisconsin, for example, during the primary was show that the polling place closures depressed voter turnout for the primaries by 8%, and it depressed voter turnout by Black voters by 10%. So closing polling places can absolutely have a disproportionate burden on voters of color, for example. And if polling places are closed in a way that is discriminatory, that is a potential target for litigation under Section 2, for example. But there's no federal law that says that you need to have X number of polling places for X number of voters. And I think that's in part because the way that states are broken down, their subdivisions are very different. So like some states, have precinct-based voting, some states have town-based voting, some states have municipality-based voting, and it would be because of the very diffuse nature and the differentiation in election systems, it might be hard for a federal bill to sort of standardize that. Having said that, it wouldn't be impossible. So I think it's certainly something that would be feasible. But I think that's why we haven't seen it to date. It's just that how different state election rules are and how they divide up their subdivisions.
Thank you. I think that you brought up, and I know a lot of people are aware of the, I think it was a statewide ballot question that re-enfranchised most of the former felons in Florida, but then they ended up having to pay fines and things like that. I guess there have been a few questions around that. I guess the first is, could you just sort of bring us up to speed on where things stand in Florida? There's just been like so much back and forth on that. And then could you broaden out to some of the other states? Are there any states that currently do not allow former felons or existing felons to vote, where there are ballot questions or other types of efforts where you think things might be changing sometime soon?
Sure. So just to start with Florida, in 2018, after an enormous amount of advocacy and groundwork there, Florida voters passed Amendment 4 by an overwhelming percentage. Nearly 66% of Florida voters approved of Amendment 4. That was 1 million more voters than any Republican candidate for office won that year. So restoring voting rights to people with past convictions is enormously popular. It is popular across the political spectrum. Americans get it. They get that people deserve second chances. They want to give people a chance at redemption. They want to welcome Americans back into civic life. So it was an incredibly effective ballot initiative. Immediately, or just a few months after Amendment 4 actually went into effect, the Florida legislature passed a bill that says what completion of sentence means for purposes of Amendment 4 is the repayment of all fines, fees, restitution, and court costs. And it's important to note that Florida has a Byzantine and very oppressive system of court fines and fees, because that's how they fund their judicial system. This is a state without income tax. So if you are going through the criminal justice system, it is being funded on your back. So it is enormously expensive to be a criminal defendant in the state of Florida, and people end up with hundreds to thousands of dollars worth of fines, fees, and costs. We challenged that legislation. We, the Brennan Center, with our partners at the ACLU of Florida, NAACP, LDF, And there were a couple of other challenges that were consolidated as well, one by the Campaign Legal Center, another by the Southern Poverty Law Center. So we challenged that law on a number of grounds, including constitutional grounds, that one, this was a disproportionate burden on the right to vote, that it was racially discriminatory, that it violated due process because nobody, including the state, had any idea what anybody actually owed. It is extraordinarily hard to know what is owed, what has been paid. The witnesses that we put up from county clerk's offices in the courts said that the system for recording payments that they inherited was a set of shoeboxes filled with cards that would record whether payments were made. So it was a very Kafkaesque system. And another substantial challenge that we made was that this violated the 24th Amendment, that this was effectively a poll tax, because the 24th Amendment says you can't be made to pay a poll tax or any other tax in order to vote. And nothing could be more clearly a tax than something that you pay to fund the government. And by the way, if the judiciary branch, got funded, the excess or anything over what the county said that they needed through those costs and fees went to the general revenue fund. So this is money that's funding the entire state. We litigated in federal court. We won after a 2-week Zoom trial. This was in April of last year. So it was certainly all of our first experiences litigating from home and via a screen. Unfortunately, we lost in the 11th Circuit. They did not agree with the very, very detailed factual findings of the district court judge. They effectively, found that it didn't matter whether voters knew that, whether people with past convictions, knew how much they owed, as long as they owed something that they knew they couldn't vote. They disagreed that it was effectively a poll tax because it wasn't something that you had to quote pay to. It wasn't. The lower court said this was a pay to vote system, and the 11th Circuit disagreed and said it's not a pay to vote system. You have to you just have to pay your court fines and costs. It has nothing to do with voting. But of course, the state law made it everything to do with voting. So unfortunately, we didn't win in the 11th Circuit. So the state of the law in Florida is that in order to be eligible to vote, people with past convictions have to have completed their probation and parole. That was always the requirement. And they have to have paid off any outstanding fines, fees, and restitution. And that there are some things that we won over the course of the litigation, so it is not all negative. So for example, the state had to develop a new voter registration form that made it clear who was eligible. The state adopted a new policy that said basically, if you've paid anything towards the disqualifying legal financial obligations, we'll count that even if it was allocated to interest, for example, we'll count that toward your underlying obligation to vote. So there were some things that were improved over the course of the litigation. And actually recently the governor modified the clemency process. So there isn't a 5-year waiting period. It's still quite arbitrary. And Desmond Meade, one of the leaders of the effort to get Amendment 4 passed, was just denied clemency again. So clemency is not an equal alternative. But, in this case, I think it was 2 steps forward, 1 step back, but ultimately that's still 1 step forward, and more people in Florida can vote because of Amendment 4. And we showed how incredibly popular that policy is.
Well, thank you. Thank you.
Sorry, that was a long one.
No, clearly it's something that is on everybody's mind. And I think, you're right. Obviously these things these efforts are politically popular. And that's part of the reason why people are interested in on this Zoom. We're getting close to the end. We're getting close to 9 p.m. on the East Coast here. I want to respect everybody's time. Eliza, any any sort of last words to wrap things up, things that you think we ought to be focused on? States, I don't want to ask you to like choose your favorite child here, but are there like particular states that just keep you awake at night? What are the things that we should go away with here?
I think particular states that we're especially concerned about are Georgia, Arizona, and Texas. One thing that those states have in common is that they are relatively more diverse than the rest of the country already, and they are becoming less white faster than most of the rest of the country. So, what is very clear about this wave of voter suppression is that state lawmakers are reacting to the browning of America by trying to limit who can vote, by trying to choose their electorate rather than having the voters choose their representatives. So I'm really grateful to all of you for your attention to these issues. I hope you can go back to your states and register voters and advocate with your state lawmakers. Tell them what bills you don't like and want them to vote no on. Tell them what bills you do like and want them to vote yes on, because there's also huge opportunity to expand voting access. And then, really fight like hell to try to get HR 1 and the John Lewis Voting Rights Advancement Act passed through the Senate, because I think we have an unprecedented opportunity to enact civil rights reform in this country. And the time is really now. I think that what we're seeing across the states has really underscored the urgency for those federal bills. And it matters what all of you say to your representatives. The accumulation of your voices really matters, and it is worth raising them.
I couldn't agree more, and thank you, Eliza. And for those of you who didn't see the slide earlier, and even for those of you who did, you get to see it again. This is how you can take action. Again, these aren't issues that we litigate at the Environmental Voter Project. We're not a litigation shop. We're not a direct advocacy shop. We're a voter mobilization shop. But this is such an important issue that we wanted to bring it to your attention. We wanted you to hear from an expert. We wanted you to be able to ask questions of Eliza. There are over 160 of you on the line right now. I'm sorry that we couldn't get to all 38 questions. Hopefully I condensed them well enough. All of these organizations are worth your support. There should be links, URLs to all those organizations in the chat right now. And also sign up, take some of your time to sign up for a calling or texting shift in states like Georgia, Arizona, Florida, Pennsylvania, elsewhere. We are talking to these voters right now, helping them vote. And so support the litigation, support the voter turnout. And finally, just thank you all for coming. Like, please dedicate yourselves, whether it be time or money or other means, to fighting these efforts. I know that many of you were calling and texting and donating nonstop last year, and you may not want to hear it, but it's time to get back in the game. It is. So whether it be with us at the Environmental Voter Project or supporting the Brennan Center for Justice's work or some of the grassroots organizations that we had up there, I entreat you, please, please, please get back in the game. This is a crucially important moment in time. So thank you for sharing an hour and 1 minute with us. Sorry, we went 1 minute over. Thank you, Eliza, so much. Please, please, everybody, give Eliza a quiet, muted round of applause. Thank you for joining us, Eliza.
Thank you, Nathaniel. It was a pleasure to be with all of you tonight.
Bye-bye, everybody.